only have a minute and a half to be able to talk to you. You have 10 minutes. 10 minutes.
Thank you, Your Honor. May it please the Court, I'm Jeff Cohen from Carlton Fields, representing National Union. The turnover suit, what we call the turnover suit, was actually a lawsuit to enjoin bad conduct that Acosta was accused of committing. What we've been calling the underlying suit was a lawsuit to recover damages for that very same conduct. That is why the underlying suit arises out of the turnover suit. Now, we've talked, and there's been some questions about the turnover suit. And, lawyers like to shorten things, and we like to pick names for something, and somehow we picked the name turnover suit. And that has played into the argument that, well, this is just give us back our computers and our boxes of files. But that is really not what the turnover suit is about. The turnover suit is about protecting the assets of the bankrupt estate and protecting them from interference by Acosta, including taking some of the boxes of files and the laptops. Let me tell you what it says, and I want to read you just a few lines from the turnover suit to make this very clear. The property of marketing specialist is threatened with irreparable injury by the actions of Acosta. You asked if it alleged wrongful acts. I suggest that that's an allegation of wrongful act. Once an Acosta...
We argue with you.
Huh?
We argue with you.
Yes, sir, please.
For plaintiff.
Okay.
Just because somebody does something that's irreparably injures someone else, does that mean that the act that the person is taking is wrongful?
Yes, sir, I would say that that does.
Okay, let's play this one out.
All right.
If I'm a bank, and I foreclose on your property, you getting thrown out of your home would be an irreparable injury to you, right? But it would not necessarily be a wrongful act on the part of the bank.
It would not be a wrongful act. I agree.
Okay, well, I think let you get away with that.
Okay, well...
In regards to a wrongful act, the bankruptcy court determined that Acosta did not engage in wrongdoing. Now, does this foreclose a conclusion that were wrongful acts at issue in the turnover suit?
No, sir. It's an interesting that you asked that question, because there, in fact, were wrongful acts, and I'm going to come back to your question, Judge Wolf, but I want to answer Judge Lewis's question first. In the underlying suit, the plaintiff moved for summary judgment, and Acosta defended that summary judgment by just the very same comment that you made, Your Honor. They came to court and they said, wait a second, you can't enter judgment against us. This all happened in the bankruptcy court. The judge in the bankruptcy court found no wrongdoing, and specifically, they allege in their summary judgment response, rather than appeal Judge Sharp's findings, the plaintiffs now seek to have this district court relitigate and urge that the district court revise the finding of its previous 105 cause of action pertaining to alleged state violations. So what you heard from Acosta in the underlying suit is 180 degrees different than what you're hearing here. What they said in the underlying suit is, wait a minute, this was all a matter that was taken up in the turnover suit, and we didn't do anything wrong, and therefore we should be entitled to be out of this case. So I hope that answers your question. There's an allegation, and this is determined by the allegations. If they were innocent or found to be innocent by the bankruptcy judge, and there's some question about whether they were actually found to be innocent, what the judge says, they certainly got the property of marketing specialists. They got it because of this interim agreement that the parties entered into. And the fact that they have this and got all of this stuff is not the fault of Acosta, it's the fault of the former marketing specialists, employees and executives that went over and went to work for Acosta and took their records. But whether it was wrongful or it wasn't wrongful is not the issue. The issue is whether it's the same allegation in both cases. And Acosta has already said it is the same allegation in both cases. And they say we were found innocent, therefore you can't sue us. So that's just different than what you're hearing here today. I want to go back to the turnover suit because you pushed me on wrongful acts. Absent the requested relief, Acosta's interference with the operations of marketing specialists will seriously undermine the debtor's reorganization or liquidation efforts. All right. This court must act pursuant to Section 105 to preserve and protect its jurisdiction and the assets of the debtor. The property rights, this is on paragraph 19, the property rights involved are unique and irreplaceable, and the consequences of any precipitous action on the behalf of Acosta would be impossible to measure accurately in monetary terms. Then they asked for an injunction against Acosta from taking any action to seize, possess, hold, control, assign, transfer, sell, or in any way whatsoever affect the interests of marketing specialists in and to its property, including but not limited to its equipment, computers, files, records, mails, and checks. So the contention that this is only about physical property is not accurate. This injunction says you cannot interfere with their property rights. And their property rights are both tangible and intangible. If you take somebody's computer and you give it back, which is what happened here, but you take all of the information on that computer and you use it for your own benefit improperly, that is a wrongful act. And that's what happened here, and that is in fact what is alleged in the underlying suit. It's the same thing. The underlying suit, they say, after this interim agreement, and the trial judge specifically found that all of these harms focused around the interim agreement. The interim agreement was done 4 days after the bankruptcy petition. They got together and they cooked up an arrangement whereby the marketing specialist people already started moving over to Acosta and taking their computers and taking these records. And there's an allegation in the underlying suit that between June 1 and June 11, in 11 days, Acosta recovered $11 million of income that would have gone to marketing specialists but for this conduct.
The bottom line, what you're saying, paraphrase, you're saying it's inappropriate conduct under the Bankruptcy Act, therefore it equates to a wrongful act.
Yes, sir, it is. Those were some of the specific allegations that were made in the underlying suit. Protect the bankruptcy estate, and they violated the automatic stay. That was alleged too. So yes, Your Honor, that is what makes it a wrongful act. And it is certainly all related. The exclusion that we have here is there's two ways that the exclusion applies. One is whether the two prongs, does the claim, and we have this contention, by the way, about what a claim is, and I want to come to that.
Regarding that contention,